of the petitioner's document from pages 1 to 209. Look at that volume. And I'll refer you to the Hansard proceedings of the Senate. You'll find the Hansard proceedings of the Senate in the documents filed by Mukele Moni advocates in the CTS that are labeled Parts 5 and Part 6. Part 5 and Part 6. In Part 5, you'll find the Hansard of 16th October 2024. Then in Part 6, you will find a continuation of the Hansard of 16th October 2024 and the Hansard of 17th October 2024. That Hansard is also referred to in the affidavit of my very good friend Jeremiah Nyegenye as Annexure JN 10 at paragraph 31 of that affidavit, which was sworn on 21st October 2024. So, returning to the question under scrutiny from my end, I will invite you to look at page 59 of the Hansard of 16th October 2024. This is now the page of the Hansard itself, not the page of the bundle, because my learned colleague, Mr. Mukele, did not paginate the full bundle. So you look at the page of the Hansard itself. Something very interesting happened. I want to paint the picture so that I abridge on time. Before the trial of His Excellency Gachagua at the Senate issued a trial schedule, a schedule of the proceedings. The National Assembly had given the Senate a list of 5 witnesses. His Excellency, the Deputy President, had submitted his affidavit alone as his own witness. So the DP side had 1 witness, being the DP only. The National Assembly presented 5 witnesses. When the schedule came, the schedule gave the DP's team 2 hours to cross-examine the 5 witnesses of the National Assembly and 3 hours to lead the evidence in chief of the Deputy President. The Deputy President's team took the view that it did not need 3 hours to take their witness in exam in chief. This is their own case. They suggested to the Speaker that we need these 3 hours for our exam in chief and perhaps the 3 hours for our cross-examination of the National Assembly witnesses and perhaps the 2 hours for our exam in chief. So we are not taking any more time of the Senate. We are just reordering our own time, the one you have given us. At page 59 of the Hansard of 16th October 2024, the Speaker dismissed that literally by wave of the hand. I mentioned three significant trials that have shown me that when these kind of things happen, it means there is malicious compliance. We are simply going through the motions. No one is asking for the Senate any more time. We're just saying, of the time you have allocated us, we have a lot more duty in cross-examination. Give us more time towards that. We have lesser duty in exam in chief. From our own time, give us less time on that. It is judicially noticeable that the Speaker of the Senate is a lawyer of many years standing. It cannot be that he didn't understand the injustice inherent in the disproportionality in that time allocation. It cannot be he didn't understand. He understood it by virtue of the trust bestowed upon him as a trained lawyer. He breached that trust. Allow me to then very briefly take you through the various grounds of impeachment as set out in the motion and the evidence, what the evidence revealed in respect of each of those grounds. I will start with the ground number 4 of the impeachment motion. The particulars of